that question should rather be directed to the jurists, who one of them is myself and or the state.
Now I'm directing.
This witness is not a jurist. He's not a legal guru.
He's a policeman. He's a policeman who takes a statement.
Yes.
I'm directing it to the investigating officer, policeman who was investigating this case. Okay.
Those are legal things, my lord. As I'm saying, they'll rather be directed to the jurists, who one of them is myself, and the second one is the state. This is a witness who's just involved on the investigating side of it. I'm not so sure whether the court would then allow me the opportunity to respond to that question.
You can respond.
Let me respond, my lord. My lord, that form.
Are we arguing about forms now? I stated a principle in law that a warning statement is only taken by a policeman who sometimes incidentally happens to be an investigating officer.
Yes.
Before he charges the person.
Yes.
Yeah, it's a prelude to being charged. In other words, as I understand the law, you can't take a warning statement and then you run around with a person and you don't eventually charge him.
That does happen, my lord.
Okay, fine.
Yes. It does.
You can argue that, but I was putting it to him that does he know that? He says he understands that. Okay?
There's no way, my lord, in which he can't say he understands, because exactly what the court has just done now is to confirm what he did, and which is wrong.
What do you mean it's wrong?
It is wrong. Let me explain how wrong it is.
No, you don't explain to a judge, please. You can argue against the judge.
Thank you, my lord. I will argue at the end of this trial.
I'm 55 years in this profession.
Thank you, my lord. I will argue at the end of this trial.
Jesus.
Thank you. Not actually at the end of this trial. I'll argue when my point, when the time comes from me to make submissions to the court.
Yes.
Thank you. The issue was about you being